George Pell, Cardinal George Pell, was acquitted by the High Court earlier today and released from Barwon Prison after being incarcerated for 405 days. The Australian's Legal Affairs editor, Chris Merritt, joins me now via Skype. Well, Chris Merritt, you have looked at many judgments over your time. The statement from the High Court today that came down at 10 a.m, a single judgment, the entire bench, pretty excoriating legal principles, I think, taken to task in relation, particularly the Victorian Court of Appeal majority judgment. How did you find today's events?
A great relief. It was the best possible outcome. What I mean by that is a clear 7-0 judgment removes all doubt about this affair. Excuse me. Had it been a split decision, there would have been a continuing debate, but a unanimous judgment and a clear statement of the law is exactly what Victoria definitely needed. The Victorian Court of Appeal has now been given a primer in criminal justice. It got itself into this embarrassing position by ignoring Mark Weinberg, the only dissenting judge who sided with Pell during his appeal. Had the other two judges, Chief Justice Anne Ferguson and Court of Appeal President Chris Maxwell, they would have read it, but had they adopted the analysis of Justice Weinberg, Pell would have been out of prison a lot earlier, and they would be in this embarrassing position.
I mean, but it's Law Student 101 that the burden of proof in relation to a criminal trial is beyond reasonable doubt. There was every reason in the jury directions and else to see that there was reasonable doubt, conflicting and uncorroborated evidence and testimony from what they call the contributory witnesses, I think, the group that were there when George Pell allegedly was on the steps at the end of the mass. How did it get so far? I mean, George Pell had to get a lot of people to help finance his case to the High Court. Most ordinary Australians would not have that access to justice in that respect. And if the High Court wasn't there, he would still be in prison. This is just an extraordinary turn of events that an appeal court could get it so wrong on basic principles that a Year 10 legal studies student would know off by heart.
It's an international embarrassment. You've got to remember that this is a very high-ranking Vatican official, viewed internationally at stake, not just by the Court of Appeal, but by other parts of the Victorian justice system. In running this case, it casts a big shadow over Australian justice. That's why this needs to be addressed quite urgently. The legal principles, as you pointed out, are pretty basic. It's up to the prosecutor to prove beyond reasonable doubt that a crime has taken place. It's not up to the defence to prove their innocence, but it looks very much like, in this case, that's exactly what's happened. And the origin of that, when you trace it right back, it gets down to how the trial was run before the jury. The argument was put that the assertions of the prosecution were impossible. Now, that, I think, poisoned the jury's mind, gave them the wrong idea that it was up to the defence to show affirmatively that it was impossible for these allegations to have taken place. That's not the case. All the defence needed to do, and the High Court has now spelled this out very, very clearly, is raise a reasonable doubt. And they did that in spades. They had plenty of supporting witnesses who made it very clear that there was a real doubt that Pell could have been where he was at the time he was alleged to have assaulted, committed these assaults. Now, that's not to say that those witnesses had proved beyond reasonable doubt that Pell was away. They didn't have to. All they had to do, and the High Court has borne this out, is show that there was a real doubt, a real reasonable doubt. And then it was up to the prosecution. And a 7-0 judgment by the highest court in the land just goes to show you how weak this case was from the very beginning. It should never have got to first base.
Well, Chris, it's two things that struck me as highly unusual. First, the jury trial. The first jury trial obviously didn't find a verdict. It was the second jury trial and then the Court of Appeal. It was almost like they had applied a civil test, the burden of proof of balanced probabilities, as opposed to reasonable doubt. They'd mixed the tests up, and even when you looked at the bench of the Court of Appeal, they had the two in the majority judgment had a civil law background, which is very different than Weinberg, who was steeped in criminal law. And if you ever want to be schooled on a criminal law judgment in this matter, please read the Weinberg judgment front to back. But when I watched the hearings in the High Court, I watched 2 days of hearing on the internet. The second day in particular, about an hour in, the DPP for Victoria, presenting the case as to why the George Pell conviction should stand, excoriated by most of the bench of the High Court. I mean, this is a very big embarrassment for Victoria. And I said in my editorial tonight, serious questions have to be asked at the Victorian police conduct of this case at the same time as Lawyer X was going on, and the interrelationship of both of these issues, Lawyer X and the Pell case, that's been found in evidence before the Royal Commission in Victoria on Lawyer X. Surely there's got to be a wider investigation into the Victorian police and Victorian legal system out of this.
Look, I agree, but I think it goes beyond that. There's procedural problems as well. The reason the Court of Appeal got itself in such a pickle is that it gave too much credence to the credibility of the complainant. Now, how did that happen? It happened because, and this is a problem for the jury as well, but it happened because there's a law in Victoria that prevents or prevented Pell's defence team from telling the jury that the complainant had suffered from psychological problems in the past. And they could also not tell the jury that they had tried to get hold of documents showing that and had been rebuffed by the court. Now, what that means, now bear in mind that this guy's evidence is the sole basis for this prosecution. There was no supporting evidence, there are no supporting witnesses, nothing, just his word. And documentary evidence existed that was withheld from the jury that would have completed the picture of this fellow's credibility, and that was intentionally denied the jury. Now, that was put in place with the clear goal of protecting complainants in sexual assault cases, and it's my view that the pendulum has swung too far. Complainants in sexual assault cases do need to be treated with some sensitivity, but when a man's liberty is at stake, and we're talking about an old, sick man, surely a jury should be given all relevant evidence and not simply given half of the picture, particularly when a prosecution depends entirely on the credibility of a complainant.
Look, I think a lot of people will want this case to go away for obvious reasons, but I think it raises more questions about jurisprudence and conduct, as I said, of these two big institutions, the legal system, the court system and Victoria Police in this state more than, actually right across the country, more than anything else, and that debate will continue. Chris Merritt, thanks very much for your time.
Okay.
All right, just before we go I'm going to go to a break. There's a tweet out by the Pope. I think we've got it there. We can put it up there on the screen. Interestingly, he refers to Lent. Of course, this is Holy Week. In these days of Lent, we've been witnessing the persecution that Jesus underwent and how he was judged ferociously even though he was innocent. Let us pray together for all those persons who suffer due to an unjust sentence because of someone had it in for them. There you go.